Hello and welcome to another exciting episode of MondAI Bagel. Today we delve into the intricate relationship between AI and law with our esteemed guest, who is today Philipp Koehler, a tech lawyer and a salary partner at Taylor Wessing, based in Munich, who inter alia specializes in platform regulatory matters and European Digital Services Act, its implementation, its challenges and developments. Philipp, the DSA completely applies since February 17, 2024. Could you briefly outline its scope and key regulations? And it's, of course, great to have you here, first of all.
Yeah. Thanks, Michael. Thanks for having me. I'm happy to contribute to your podcast, and of course, I can give a short overview on the DSA. So, in a nutshell, the DSA is an EU-wide regulatory standard. It stipulates uniform rules in the EU for the operation and provision of digital intermediary services. And intermediary services, in the sense of the DSA, comprise obviously many different services. For instance, I would say the usual suspects are web access technologies, web hosting, app stores, online content sharing platforms, social networks, online marketplaces, and online search engines. And with respect to the underlying legislative motive, the DSA's core aim is to provide a safe, predictable, and trusted online environment, which is free from illegal content and where European fundamental rights are respected. And when we take a look at the core provisions, the DSA has basically three main regulatory components. The first one is liability exemptions, also known as safe harbor principles. The second, and I would say the most important one, is new extensive due diligence and transparency rules, including rules on handling illegal content, in particular content moderation, complaint handling mechanisms, transparency, fair design, e-commerce, and online advertising. So you see a lot of different stuff is regulated by the DSA. And the scope of applicability of these rules is structured as a tiered regulatory system of the respective classification of the provider under the DSA. That means depending on a specific classification, you have less or more rules. And so the minimum rules start with mere conduit and caching services. Then you have increased rules for hosting services. You have further rules for online platforms, and you have the maximum rules for very large online platforms and search engines. And the last regulatory component that I want to mention is new rules on optimizing enforcement, cooperation, and coordination between the authorities at European and domestic level. That basically sums up the DSA in a few words.
We could speak about it probably for an hour or longer, but what do you believe are the most significant technical, organizational, and personal efforts required for implementing DSA's requirements?
Well, there are actually quite a few. I mean, I would say the DSA is quite similar to the GDPR, when it comes to like new obligations that are set up, and providers obviously have to get accustomed to them first, make some sort of gap analysis and then try to achieve compliance. But I would say, as most affected providers have probably realized by now, the DSA causes versatile technical, organizational, and HR implementation efforts on many fronts to achieve DSA compliance. And let me just note a few which I find to be the most significant ones. So you have the obligation to create and publish regular, extensive, and granular transparency reports, either annually or semi-annually, depending on the size of the provider. Those transparency reports are especially connected to the receipt and handling of court orders, restrictive measures taken at own initiative by automated means or based on third-party notices, as well as complaint handling procedures and out-of-court dispute settlement procedures. That is basically the first one of many additional ones. I think another point that creates a lot of efforts is going to be to establish well-running and transparent processes for content moderation, restrictive measures, and complaint handling. So you basically have to set up a framework, where all the requirements that the DSA stipulates are achieved. Then another one would be to establish a framework where you cooperate with out-of-court dispute settlement bodies. You have to establish a framework to increase the transparency of advertisements. And at last, with respect to B2C online marketplaces, you have to establish a framework where you verify the traders that act on your marketplace.
Okay.
I would say those are more or less the ones where I would say they create quite some efforts. And as you can see, it's really depending on the respective requirement, but some require more technical implementation efforts, some more organizational, and obviously I would say like almost any provider will have to get some more personnel in order to get the things rolling like the DSA wants to have them to be.
Okay. This podcast is about AI and law, so we of course today focus on DSA, but I would like to start the next part when we compare a bit AI Act and DSA. Is it comparable at all? It's both digital acts, or regarding digital markets, not only of course because AI Act can regulate also AI embedded in not only digital world itself, but most of the companies are from the digital world. Can we
Yeah,
compare it?
we can try to compare it. I think it's kind of comparing apples and oranges because both acts definitely have completely different regulatory subjects. Like when you take a look at the DSA doesn't explicitly regulate AI. In fact, the term AI can't even be found in the DSA. What the DSA does is it stipulates additional requirements if a DSA provider implements automated means or algorithmic systems, which can obviously also include AI into its service. So I would say when you put those two acts aside each other, I would say they do not exclude each other, rather they complement each other. So if a provider uses AI in its systems, he certainly has to obey the AI Act, but on top he has to obey the DSA. So I think that's more or less my general perspective on it. But still, as you said, there are some things where I would say there exist similarities. I would say one common denominator of the two acts is certainly transparency and accountability. Both acts try to considerably increase those two aspects. And then you have a lot of different structural similarities of the two acts, which are, for instance, the overall aim. So you have both acts kind of want to strengthen the European single market by fully harmonized rules. They want to create a trustworthy environment where European fundamental rights are respected, and they want to foster innovation. Then I think another similarity is that both acts have a tiered regulatory system, according to which requirements become stricter based on potential imminent risks. And another commonality would also be that they prohibit certain practices. So you have the forbidden AI practices and you have a few forbidden DSA practices. And there is even one which is actually almost identical, which is the prohibition of deceptive design patterns, also called dark patterns.
Mhm.
But I would say the DSA prohibition in that context is a little bit stronger because it's not depending on significant harm for the affected person, which the AI Act does.
I would add a similarity of territorial scope that it's regular. You can both apply AI Act and DSA regardless of the provider's location or the entrepreneur's location. Of course, not in all the situations, but in some situations, both acts provide roles called deployers, providers. Can we align these roles between two acts? Who are the common deployers and providers in DSA context?
Yeah. We can certainly do this, but let us take one additional comment on the geographical scope. You're completely right. I think the geographical scope of the two acts is certainly another commonality. And I think that is just, the approach that we have to get used to. Like, I mean, when you take a look at former regulations from the European Union, I think like it started with the GDPR, the
Mhm.
approach that we have in the AI Act and the DSA now. So obviously the European Union wants to kind of tackle companies that do not have an establishment in the European Union as well. And so the point of contact for the applicability will somewhat be that European users are targeted. European users are the recipients of services from providers under the DSA or under the AI Act. So that is definitely something that both acts also have in common. And I would suppose that this is also something that we will see in future regulations as well, because that is just a common approach that the European legislator is just taking for like, I would say, most of the new regulations which are tackling digital business services.
Data Act has also a similar regulation trying to cover some activity, some operations from companies not actively operating from the European Union. But let's go to these roles. Who is a provider under DSA?
It's kind of interesting to see, how those regulations have a completely different setup when it comes to the provider, deployer, or different category addressees. So the DSA does not really define the term provider. So it only defines what kind of services are subject to the DSA, and that are the ones that I mentioned earlier. So you have like web access technologies, app stores, online platforms, content sharing platforms, and so on and so on. But the term provider itself is not really defined under the DSA. So provider basically just means the entity or person that operates or provides the specific intermediary service as defined by the DSA. So under the DSA, it doesn't really make a difference if somebody develops a certain service or is just using the certain service, as in the AI Act. So you don't really have the differentiation between provider and deployer. You have just the provider regardless of the development aspect. And when you take a look at common providers under the DSA, especially in context with are they provider or deployer under the AI Act, I would say the big tech platform providers will most likely be deployers under the AI Act, because the AI that they implement will highly likely be developed by themselves. So I guess they would be provider. And when you have smaller providers under the DSA, they will likely be qualified as deployer, because they will likely have bought such AI in order to use it and not developed it by themselves.
Okay, and we all who are deep in AI Act know about risk-based approach it uses. It was the major differentiation between companies or providers or roles, prohibited actions, activities, high-risk activities and operations, and other. Does the DSA includes risk-based approach in your opinion?
Yeah, I mean, the whole structure of the tiered regulatory system is kind of a risk-based approach. So you have different categories of services under the DSA. So it starts with mere conduit services, caching services. According to the legislative's understanding, they have like more or less the lowest risk potential. So they have only basic obligations. And then you have hosting providers, which are supposed to have more risks for societal aspects. So they have more obligations accordingly, and accordingly it goes further. So the next threshold would be online platforms, which have more risks. And at last, you have the very big online platforms and very big online search engines who have the strictest risks. So I would say the DSA has, by its structure, definitely a risk-based approach.
Okay, so it is construed as a risk-based act, but no, except for VLOPs, very large online platforms, or very large online search engines, no self-assessment of
Exactly. So
the.
the only self-assessment that you have is with very large online platforms that have to do a self-assessment of systemic risks. And systemic risks means that are risks stemming from the design or functioning of their service, or from the use made of their service. And the term systemic risks is also defined. So it's very, very broad. So it remains to be seen how these risk assessments will develop in the future. But basically, they include the dissemination of illegal content, negative effects to European fundamental rights such as human dignity, freedom of expression, non-discrimination, and minor protection, negative effects to civic discourse and electoral processes, as well as negative effects to gender-based violence, public and individual health. So as you can see, it's very, very broad.
Mhm.
And those and after the provider of the very large online platform or search engine has identified those systemic risks, they are subject to reasonable, proportionate, and effective mitigation measures.
I could compare it to self-assessment under AI Act. It's a bit similar to this high risk factors. But let's go to the next question. I would like to ask you to come back to one of your previous statements when you said that a lot of DSA requirements must be bound with more personal. Is it really required, or maybe some companies may use or even already use AI to fulfill all these obligations? Is it possible to meet all these requirements really by people only?
I would say it really depends on what the DSA allows. So you have different aspects where the DSA kind of specifies what you have to do when you use algorithmic means or automated means or whatever. So as I said, AI is not really specifically mentioned in the DSA, but it at least mentions automated means and algorithmic systems. So that definitely includes AI, and there are definitely areas where providers are allowed to use artificial intelligence. That is, for instance, content moderation. So, like a lot of mechanics can be performed by and executed by artificial intelligence, and that is definitely something that at least the big tech players already do on the market. Even before the DSA became applicable, they were already doing it because obviously, those measures save a lot of HR efforts. You don't need as many people, as many humans to perform certain tasks when you have AI that is able to kind of perform and execute those tasks. And content moderation, I would say, is definitely one of the main areas. So when it comes to detecting and assessing and removing certain content from platforms or other intermediary services, that is certainly something which is already widely used in practice.
And can you mention some other technique, some other tools or techniques where AI may be used, or AI-based tools may be used for DSA purposes?
Yeah, sure. So I think another one could be complaint handling. So when you have like certain complaint handling procedures, for instance, when content was disabled or removed from the marketplace, the user has certain rights to complain about this. I mean, it's at least conceivable that those contents were removed without sufficient justification, and so those complaint handling procedures can also be performed, at least to some extent, by artificial intelligence. But the DSA clarifies that those decisions that come out of such evaluations need to be subject to human review. So this is something where AI can certainly provide some sort of aid, but the final decision needs to be made by a human.
And can we say right now how it's used in practice? Are there any database? I know that there are some. So
Yeah.
but can you elaborate a bit?
So what we can certainly say is that content moderation is predominantly done by artificial intelligence. So you have the DSA transparency database, which is a publicly available database that contains all restrictive measures undertaken by online platforms. And this DSA transparency database says that at the moment, I looked at it today again, so 69% of all restrictive measures, such as disabling content or removing content, is conducted by fully automated means. So that is definitely something where we can say automated means, artificial intelligence, and so on is in full use. It's quite difficult to say how it is with complaint handling because we don't have a database that kind of gives us statistics about how many of those complaints were at least aided by artificial intelligence. But yeah, I guess it's at least an aid. But as I said, the thing is, it needs to be subject to human review. So I think it's not going to be as intense as it is with content moderation.
But it's still a great number. 70% of all the mundane, in fact, tasks regarding
Yeah.
regarding content moderation already transferred to algorithms and
Yeah.
robots.
Yeah,
It's
I mean,
impressive.
it just shows, that this is something that is just needs to be implemented, because I mean, when you take a look at how much efforts that would be from a personal human perspective, that is just hardly feasible to do it only by humans. So I think that is basically something without an alternative. You just have to have some sort of automated means. And I think the problem that many providers on a smaller level have at the moment is more or less, getting the financial resources in order to be able to buy and implement such automated means. I think that is more or less the main reason why many providers at the moment say no, we can't afford such technical measures that are sophisticated enough, so we have to do it by humans. But basically, the more content that you have on your platform, and I mean, take a look at the big tech platforms, they have sometimes millions, even billions, on content pieces uploaded every day. So it's would just not be possible to do it just by human review.
So I wonder how they handle to meet both the DSAs and AI Act's requirements that come in some months. Philip, thank you for a great discussion. You gave insights. You gave them in a nutshell, but very meaningful. Thank you for sharing your knowledge. And for all of you, thank you for joining us today, joining our discussion. And if you found this episode insightful, don't forget to tune in next Monday for another deep dive into intersection of AI and law. Thank you, Philip.
Thank you also, Michael. It was very much fun, and yeah, and it was very cool of having the possibility to contribute something to your podcast.
Thank you.
Thank you.